gentlemen of the jury, I am addressing to the world community of jurors to understand what is going on before the United States Supreme Court of America. Corruption all over the world. Corruption, you name it, every part of the world there is political corruption. Even in India, where I am now speaking, we have attack on the Supreme Court of India. There's a fight going on in the Supreme Court of India. I'm not going to go into that, but we are talking about the corruption within the United States of America. To those who have not seen my documentary in YouTube under the caption David versus At&T Part 7 and David versus At&T Part 8, this is a refresher. Those who have read, seen that thing, they know what I'm talking about. But those who have not seen that, give you a short history. I was working for At&T as a legal analyst in their antitrust legal department in Orlando, Florida during 1979 through 1981. We were working on various antitrust cases, monopolies cases. We were a team of 1,500 people working there in 7 buildings. On Monday morning, as usual, At&T gave me a semi-annual merit increase of $5,000 and a fully satisfactory job performance rating. Monday. Friday, I am fired from my job for no reason. The reason is I refused to take a sum of money offered to me to voluntarily leave the company because At&T was disbanding the monopolies division after they settled a case against them brought by the US Department of Justice. I'm a family man with 4 small children then, and my dependent father living with us. I said, I don't want the money. That's the basis. They fired me abruptly without any notice and hearing. To cut the long story short, I sued these companies, At&T and my former employer, which is Michigan Bell Telephone Company, pursuant to the rules after obtaining a right to sue letter. That's a procedure. You have to go through the administrative agencies which refused to investigate based on the deal they had worked out with these defendants. So they refused to conduct. They issued me a right to sue letter. I sued these companies at the Middle District of Florida in Orlando under case number 82-200 CIV-R. R stands for the name of the judge assigned to the case, who was Judge John A. Reed Jr. He is now dead a couple of years ago. Now, defendant At&T admitted terminating me illegally in violation of the laws. The law says they can't discriminate a person because of his national origin, color, gender, age. These are the factors upon which I brought a $10 million lawsuit against them. The defendant's argument was they had made me sign an agreement which says I quit the job, which is totally inconsistent with the arguments. They fired me in the presence of my former wife at a hotel lobby. Now they are arguing, yes, Mr. Devi fired him, but he signed a release. The question before the court is whether the firing is illegal or not, and whether I quit my job freely, voluntarily and knowingly or not. This is what is the US Supreme Court held in Alexander versus Denver Gardner, decided in the year 1973. The holding of the Supreme Court of America in the Alexander case is an employer can obtain a release from an employee provided he signed the release freely, voluntarily and knowingly. So the issue faced by the judge is whether the release is valid or not, and he issued an order denying the defendant's motion to dismiss as per exhibit, which you will see shortly in this video, which I am going to show to you right away. Now, the judge has the authority to order the parties to attend for a conference, to decide discovery matters. You are going for a war. But the judge says, Mr. David, we will not give you any discovery, we only give it to the defendants to prove their case. You have to understand the whole thing, gimmicks, what is going on, which you will know as we go further. The defendant propounded 1,300 what is called interrogatories and or request to admit. They sent it to my lawyer. I was then represented by a lawyer by the name Syriac D. Kapil, who is a gentleman from Kerala, and he was practicing law in Chicago. So I hired him. He came with me to the court. The judge made a ruling. Fine. Now, my counsel was, excuse me, subsequently murdered. Syriac Kapil was murdered. I have my own suspicion because they tried to make him a judge, which he declined. Then they tried to give him cases so that they can get him, he can get out of my case. So these are the tactics they deployed the defendants and their counsel. They didn't succeed. Mr. Kapil was eventually murdered. According to the press report, he was murdered by another Indian fighting against his brother. I didn't know his murder came to know much later because I live in Orlando and I live in New York at the time, and he was murdered in Chicago. Folks, the issue facing the court is whether the release is valid or not. Simple issue. A 3-page document executed by me, and the court has to decide from evidence whether Mr. David signed the release freely, voluntarily and knowingly or not. That's the issue facing the court. But the defendants do not want that. You understand? I demanded a jury trial. That is the constitutionally guaranteed right given to every citizen living in America. If the amount in controversy is over $20, a party can demand, the right to demand to have the case tried before a jury. The jury means members of public who are registered voters. They only have the right to appear as jurors. And we will present the case to the jurors. They decide from the evidences submitted to them who is telling the truth. Mr. David, with 4 small children, a dependent parent, a dependent father, he quit his job, or was he fired? That's the question. So the defendant At&T doesn't want that. You understand the gimmicks here? AT&T, excuse me, subsequently called me for what is called a deposition upon oral examination. They call in the state court EBT, evidence before trial, or in the federal court they call deposition. That means they ask questions, I respond. And the same testimony is going to be presented to the court, and they can impeach if I lied. They questioned me and my former wife, in whose invited presence I was fired. They questioned me, her, for 3 full days. We call legally, it's a fishing expedition. You put the bait and then try to pull, you get no fish. So that's the fishing expedition. They utterly failed. If they couldn't prove, they have no case. The judge has to then rule whether my termination of employment is in violation of the various laws passed by the US Congress, namely ADEA. ADEA stands for Age of Discrimination in Employment Act, Title 7 of the Civil Rights Act, which says they can't discriminate you because of your national origin, color, gender. There are a lot of laws passed by the US Congress. So, now the defendants deployed tactics to prevent this judge conducting an evidentiary hearing to determine whether the release is valid or not. What they did was, they went behind my back, hired the judge's former law clerk and a close friend of the judge, a woman by the name Anne C. Conway, who was then an attorney, a private attorney, working for a major law firm in Tampa by the name Carlton, Field, Emanuel, Cutler and Smith. It's a major law firm. So their scheme was to bring in this woman, persuade the judge not to conduct a trial. Without disclosing that she is a close friend of the judge, she was meeting him at his home. You have to understand, the opposite party's lawyer meeting the trial judge at his home. He was going to her home and meeting her there with the money, of course, because those days federal judges made only $73,000 a year. You understand? So they are more susceptible. I have no proof because I was not chasing them. I didn't know at that time what was going on. The judge will not conduct the evidentiary hearing for no reason. What he does is, he will call us a status conference, not in the open court. What is the problem with the judge conducting an open court hearing? He won't do it. He says, come into my private chambers, Mr. David, come upstairs. So when I go to the courtroom, the chambers of the judge, they were only bullshitting. They're not talking anything about conducting the trial. Okay, this woman pretended as if she knew nothing. Okay, Anne C. Conway, who then was a private attorney, she kept quiet. And this conference went on few days, not few days, quite infrequently. One of his such pre-motion conference, what they call, he ruled there is a triable issue of material facts remain in this case. That is his ruling. You will see his ruling. According to the US Supreme Court, they decided 3 precedent-setting cases in 1986. Those cases are Anderson versus Liberty Lobby Inc., 477 Supreme Court 242, decided in 1986. Another case, Silotex Corporation versus Carrot, 477 US 317, 1986, and Mitsushita Electric Industries Company versus Zenith Radio, 475 US 574, 1986. The Supreme Court of the United States in the year 1986 held you can't have a motion for summary judgment and have the case disposed of unless there are tribal issues. So the Judge has to conduct a trial, which the defendants do not want. You understand the gimmick here, gentlemen, ladies, those who are lawyers, you know what I'm talking about. Those people who are not qualified to practice law or who have not studied law, the judge has to decide questions of facts before a jury as demanded by me, but he doesn't want to do it because the woman says, AT&T lawyer says, Your Honor, we don't want a trial, we don't want a jury trial. So the scheme was put off my case under various pretexts. I became suspicious of what is going on. I didn't know at the time this woman, Nancy Conway, is a close friend of the judge. They were meeting each other at their homes and other places. I sent the judge a questionnaire consisting of 20 questions for him to answer. As soon as the judge got this questionnaire, he knew I knew something going on. He understood what is going on because of corruption here. A judge, a federal judge, sworn to uphold the laws, meeting the opposite party's counsel at her home and his place and elsewhere. As soon as he received my questionnaire, the federal judge, U.S. District Court judge, called me on the phone to Yonkers, New York, where I was then living with a friend of mine. Okay, after a painful divorce with my first wife, the judge called me and said, Mr. David, this is Judge John Reed. I got your questionnaire. I'm not going to answer them in writing, but I will give you answers over the phone. A federal judge calling a non-attorney litigant to his home in New York from Florida and telling me, I was in a state of shock. A federal judge calling me. I said, Your Honor, thank you for calling me. I would like to have permission to tape record your responses. So the judge put me on hold. He consulted possibly AT&T lawyers from Chicago or New York or Washington, wherever they are, and the other people surrounding him in the court. I'm sitting in New York. So the judge said, yes, Mr. David. He says, I am a shareholder of this company, AT&T. First. Second thing he says, I used to work for another subsidiary of AT&T, Southern Bell, before I became a judge. 3. I was meeting this woman in Atlanta. I was meeting her at her home. She was coming to my home and the case is pending before the judge. Folks, he made numerous other admissions. I promptly reported him to the FBI, Orlando, and also to the former Chief Justice, Honorable Warren Burger at the U.S. Supreme Court. As soon as Judge Warren Burger got my complaint, he ordered, apparently, Judge John Reed to recuse from the case. And Judge John Reed resigned from the bench. You understand? Now, folks, you have to understand the whole situation here. When a judge resigns, dies, or becomes totally physically unable to perform his duties, he goes, then the case has to be reassigned to one of the judges in the same court. You understand? You can take a case going on from one jurisdiction to a totally different jurisdiction. This is not a criminal case. It's a civil case. You understand? It's a civil case. Now, Judge Reed had made a deal under the table with the defendants. You have to understand, this is a federal court. Dealing and wheeling taking place every day in American courts. You fix cases depending upon your abilities to buy justice. So the case was transferred from Orlando to Tampa, which is about 80 miles away from Orlando. Judge Hodges, Terrell William Hodges, you see the guy here, he issued an order directing me to appear before him from New York to Tampa for yet another status conference. Although I never lived in Tampa, I have nothing to do with Tampa. The cause of action did not arise in Tampa, so the court has no jurisdiction. But he says he's the chief judge. He has the authority, the divine theory of power. The king can do no wrong. He is the chief judge of the Tampa court. I appeared before him. It's a civil case. But on the notice board, he stated, additional security is required, as if I am a wanted criminal appearing before a criminal court. I am a civil litigant. I didn't have even a parking ticket when we were living in Florida. Okay? So I was sitting before this judge surrounded by the security personnel, marshals and additional gun wielding security people. I told the judge, Judge Hodges, you have no jurisdiction over me, and the At&T has their corporate headquarters then in New York, and I live in New York. Transfer the case to New York. No, Mr. David, your motion denied. He said he will conduct the proceedings pursuant to the standard laid down by the first judge, John Reed. He issued an order to that effect. Did he conduct the trial or hearing? No, folks. At&T had another scheme. It's all scheme. Judges playing games, taking money, although I have no proof to show they were taking money. Okay? So under the scheme, this company, At&T, dismissed another division manager by the name Orville E. McDonald, who was a division manager working in their New Jersey facilities. He was also on a rotational assignment as myself from Michigan Bell. And they gave him $12,000. Understand, this is a scheme, well orchestrated scheme. McDonald, instead of going to the federal district court, he went to the state court. Given there is a conflict, the decision of the federal court prevails. Like in India, if state of Kerala passes a law which is in contravention of the central government laws, the central government laws will prevail. In the American court system, this guy went to a state court in Michigan. Michigan court ruled McDonald must refund the money before he can sue them. That is a per curiam, one-man decision which is unpublished, which has no precedental value. You can understand the gimmicks here. So, as soon as he obtains, the counsel for the defendant, obtains a copy of this per curiam unpublished opinion, he brings it to the Tampa court, tells Judge Hodges, Your Honor, Mr. David signed a release in Michigan. The Michigan law applies here. So you should dismiss the case unless Mr. David pays the money back to them. The US Supreme Court later held there is no tender back required in a case called the Supreme Court in Aubrey versus Enderby, 522 US 422, 1998 held that if you are a Title VII and ADA claimant, you need not tender back the consideration. That's the Supreme Court's holding. So, the validity of the state court's order, per curiam unpublished order, has no value. But what this judge does is, as soon as he got this unpublished copy of the unpublished order and opinion from the Michigan State Court, he directs his clerk to dismiss the case as without prejudice. You will see a copy of the judge's order. He says, dismiss the case without prejudice. Without prejudice is a legal term. It means it is an interlocutory order which can be changed by the court at any time. So what the defendants do is their lead counsel from the law firm of Carlton Field, Emanuel, Cutler and Smith, by the name Peter W. Zinneberg, who is running now a law firm on his own, he files a false affidavit. Now, hold on, I forgot to tell you. When the judge issues the order to dismiss the case as without prejudice, I didn't know at the time the meaning of the term without prejudice. I filed an appeal before the Court of Appeals for the 11th Circuit. So what they did was, AT&T, when they greased the palm of the clerk by the name Donald Brown, who altered the court's order as a dismissal on the merits. You understand? There is a vast difference between a dismissal without prejudice and on the merits, which many of the American lawyers don't know. Many of them. I asked them, subsequently, what is the difference between these two legal terminologies? Nobody knew. These are practicing lawyers licensed to practice in America. I was later on, let me continue with the story. So the clerk altered the judge's order as a dismissal on the merits. On the merit means the judge heard arguments, seen the testimonies from the people, the witnesses. He did none of the things. The judge, William Hodges, did none of the things. As soon as he got this order from the copy of the order from the Michigan State Court, he issued an order drawing his facts from his hat. If a judge doesn't listen to the parties, didn't have an opportunity for me to oppose the motion pursuant to the Federal Rules of Civil Procedure, how can he make a findings of facts? You understand? You have seen this judge only once for a status conference. Then he issues a findings of facts containing 5 pages, which I am going to show here. dismissing the case without prejudice. The clerk alters, Donald Brown. Now this guy was doing this very often to those who wanted it for a kickback or pocket money. Two judges in the same court reported this guy as incompetent and he was fired. Two judges, Patricia Fawcett and Judge Kendall Sharp, reported him as incompetent. So he was fired, the clerk of the court. Now, the objective of the defendant is, you have to understand, what is the underlying objective, changing the the court's order into a dismissal on the merit is to enable them to have the case affirmed by the appellate court. So, they have the scheme, they had made an arrangement under the table with the clerk of the appellate court. I believe that person's name was Miguel Cortes. Now, under the rules, the appellate court clerk is required to ensure that court has jurisdiction. If the court has no jurisdiction, you cannot file the case before the appellate court. USC 28 USC 1291 says the Court of Appeal has jurisdiction to hear a case from a final decision of the district court. Is the decision final? No, it is an interlocutory order issued by Judge Hodges. So, counsel for the defendant, who is licensed to practice before the US Supreme Court, schemes. He files a false jurisdictional statement, you will see here, saying the Court of Appeal for the 11th Circuit has jurisdiction pursuant to 28 USC 1291. They are required to make this statement pursuant to the rules. So, this attorney by the name Peter Zinneber, along with the Kathleen Walbott, I never met her, never in my life, nor Pete Zinneber, I never met these guys, none of them, because they operate through the Charlie's Angels. They don't appear in person in any court. They use the Charlie's Angels to accomplish their mission. So these two attorneys, along with the in-house counsel for the defendant At&T and Michigan Bell, swear this court is appealable pursuant to 28 USC 1291. Understand the scheme, folks? They cook up the whole thing. Okay? Now, to succeed, they got to have a corrupt panel of judges also. US Court of Appeal, to the best of my recollection, had then 29 judges. Many of them are seniors, many of them are active judges, but they know from their experience which panel the case should go to. You understand? This is how they fix the case. Major corporations in America, this is what they do. If they want to beat our adversary, they have to have the case assigned to a panel sympathetic to their political beliefs, subject to they are getting money under the table, okay, which I can't prove. How can I prove? I don't work for the FBI, okay. So this case went before Judge Robert Vance. Judge Robert Vance was subsequently murdered by a Moody by sending him a Christmas gift in the mail, which is a bomb. So he was killed instantaneously, but he was one of the members in the panel. The second judge was Clarence Allgood. He took a gun and shot and killed himself. But you understand, the United States Court of Appeal judges for the 11th Circuit, one got murdered and the murderer himself was executed a few months ago, I believe in April or May this year, after spending so many years in jail. We are not going into, I tried to contact the murderer on the phone to the prison where he was kept, but they would let me talk to him. I sent him a letter, there was no response. I want to know why he murdered this judge. I want to do my own investigation, whether there is a corruption mill at full swing there. Otherwise, no litigant will send a bomb to the judge and kill him. The second judge committed suicide. Why? A federal judge, Federal Court of Appeal Judge Clarence Allgood committing suicide. The public have no right to know. They don't get any information. What caused him to commit suicide? Folks, the third judge, a black guy by the name J.L. Edmondson. You Google it, is pro-corporation. You understand? Now these three judges, without making any opinion and accepting jurisdiction, simply affirmed. One word, I am raising issues, not jurisdictional issue, on the merit. So these puppets affirm, one word. See the document. I move to the Supreme Court. Folks, now you have to understand the inner functioning of the US Supreme Court, without which you will never get a clue to what is happening here. So in the Supreme Court, legally speaking, they have what is called the panel of people advising the court. I have here list of law clerks of the Supreme Court of the United States. Okay, list of law clerks. Each justice at the Supreme Court gets as many as 5 or 6 law clerks to enable them to get the facts of the case and the issues. Now, under the scheme, again this is a scheme. This case goes to certain select law clerks. They will tell the justices, this case has no merit. It's a frivolous and malicious, as I'm going to show you later. Now, the Supreme Court in 1986 denied my petition for writ of certiorari on the basis of the pleading, on the basis of the opposition filed by Peter Sinova, the same attorney. He says in his brief, case number 6168, if I recall correctly, he says, the order of the court, the Tamba court is an interlocutory order. So he can change the order at any time, so the court has no jurisdiction to review the decision of the court below. Here, folks, the attorney who said this is a final judgment on the merit, submitted to the 11th Circuit is a final judgment on the merit, now is telling the Supreme Court of the United States it is an interlocutory order, the court has no jurisdiction and persuade the justices to deny certiorari at that 86. At that time, I don't think we had access to the Supreme Court's decisions, a lot of stuff. Folks, when I was working in another law firm in New York, I happened to read the Law Journal, which explicitly stated the difference between a dismissal without prejudice and a dismissal on the merits. So, I made a motion under Rule 60B or 59 of the Federal Rules of Civil Procedure to Judge William Terrell Hodges, asking him to correct the error, to rectify the error, because the court's order was to dismiss the case without prejudice, which the clerk altered. So Judge Hodges issues an order in 1991 saying that my clerk had made a mistake. Okay? So I am ordering the new clerk to enter an amended judgment. So on January, let me look at the date here. This is my exhibit G1 through 5 before the US Supreme Court. He says, let me read the last paragraph. Correcting the judgment to reflect that intent will not circumvent the court's prior orders. Upon due consideration, therefore, plaintiff's motion to correct the judgment entered on January 9, 1986 is granted. The clerk is authorized to enter judgment that this action was dismissed without prejudice as of the date of entry of original judgment so ordered and done at Chambers on 30th day of January 1991. So after 5 years, after the Supreme Court denied certiorari, the judge is now telling me our clerk made a mistake. The clerk who is dismissed, Donald Brown. So he ordered the new clerk to correct the judgment. Folks, you have to understand this is a legal gimmick. Okay? So if the clerk had made a mistake and the judge corrected, what is the effect of the prior judgment? It's a nullity. Okay? But this judge, Hodges, will not do anything after issuing the order. The judge cannot have a case sitting there indefinitely without finalizing. What he did was enter an amended judgment dismissing the case without prejudice, which is not a final judgment. You understand? So he kept quiet. All the players are in cahoots with each other. The judges, the law clerk, the At&T, all the lawyers involved start playing games, thinking they can play a Mickey Mouse game with this little rat. The big cat, they can kill the little rat, okay, and the little rat here. So the big cat's trying to beat me by tricks. You understand? Ladies and gentlemen, the judge did nothing. At&T never paid me a dime. I am entitled to get my pension under the ERISA rules, Employees Retirement Income Security Act laws. They won't pay me that yet. So I brought a new action in New York. The New York scheme is, as soon as I filed the case, you have to understand the scheme going on. the clerk, they have specially picked trained clerks. They will look at who is the defendant and they will assign the case to certain judges of their choice. This is inside. They say we have a random assignment, that's bull. The lawyers objected to this, those practicing lawyers, what is going on there, assignment of cases to judges who are favorable or belonging to one political party or the other, relatives of the lawyers. So a game going on in New York, the world knows about it. So Judge Joanna Seibert, who is a Bill Clinton appointee, got the case. Case number 063199. Hold on, let me double check it. I don't want to give you a wrong citation. This case goes to Judge Joanna Seibert. Under case number 06 CV 3199, assigned to Judge Seibert and AKT, I think Judge Tomlinson, who is the judge assigned to do the discovery. Now, defendant only looking for political connections. So they went to a firm called Fulbright and Jaworski. Fulbright and Jaworski is a major law firm having around 33,000 lawyers, 33,000 or 3,300, I don't know. Now it's a major international law firm who is currently known as Norton Rose, Fulbright and Jaworski. So they went there, hired a black guy by the name Ralph Curtis Dawson. I call him the Black Monkey. Okay? It's a derogatory term, but what he did makes him a black monkey. What he did was, he said to AT&T, don't worry guys, we have some tricks here. So he calls his co-counsel by the name Brian Wayne Tilker. Who is licensed 1 year previously, in 2005. So it tells Mr. Tilker, file a false affidavit. You understand? File a false affidavit. So Tilker prepared a 3-page affidavit, sworn affidavit, testifying he has personal knowledge about the facts, how and when I executed the release in Michigan and blah blah blah, and how the defendants managed to get a judgment on the merits from the Tampa District Court, which is false, which was affirmed by the 11th Circuit Court of Appeal and certiorari denied by the Supreme Court. As soon as this sucker files this false affidavit, no hearing. You have to understand, no hearing in any of the courts. They file the papers and let the Charlies do the walking, and the marble do the walking and fingers do the talking. That's their strategy. Marble do the fingers do the walking and marble do the talking. So the Charlie's angels involved, you pay the money and so they will accomplish the mission. This judge, Joanna Seibert, issues a 19-page order and judgment citing Tilker's affidavit at least at 12 or 16 places. That's the basis for granting a summary judgment, despite the Supreme Court's holding in the three cases. When there are tribal issues, material facts remaining, they can grant a summary judgment. The judge says, Mr. David's case is dismissed based on what this sucker Tilker said to the court in a written affidavit. There are two violations of the canons. One, a lawyer cannot be a counsel and also a witness at the same time. By testifying as a witness, he breached the canons. Okay, one. Secondly, and far more important, when I got this sucker's affidavit, which you will see, he was born, according to the New York Unified Court System, on May 5, 1979 in New York. I signed the release on August 25, 1981 in Michigan. So how old this sucker was? 2 years old. Somebody born in 79 saying he has personal knowledge, and he's submitting this false and perjured testimony to this bitch, Judge Joanna Seibert. And she doesn't care what he says. The lawyer's affidavit, he took it for granted, he can testify so. You will see what the judge said with regard to Tilker submitting false affidavit. Okay, folks, you have to understand how the name of the game works here. Now, under the scheme, most elaborate scheme in the history of America, they have schemes to have which panel of judges in the appeal court, as they did in Atlanta. So, Judge John Walker, who was the then chief judge, I believe, Rena Raggi, and Judge Rakoff. Before whom I filed the brief questioning how a judgment can be granted on the basis of a 2-year-old person's affidavit. They don't care a damn about what I say. They affirm. You understand? This is the operation of the kangaroo court. You have to understand the inner functioning of the United States courts. This judges issues an order, 1 page or 2 pages, and they deny without any reason. My question that I raised to the Appellate Court, Second Circuit Court of Appeals, was how a 2-year-old person's affidavit can be used, which itself is a violation of the canons of ethics, and a 2-year-old person cannot testify because he was lying. Somebody living in New York, he can testify what happened 600 miles away in Michigan, and he says he has personal knowledge. And this bitch, Joanna Seibert, grants a summary judgment. Folks, if those who are educated, those who are lawyers, they know what I'm talking about. Let alone the ordinary common man who did not go to the law school, or those who are studying law, they should know what I'm talking about. Oh, Supreme Court again. Supreme Court denies search. Understand? Supreme Court of the United States is a rubber stamp. They have a pre-printed machine, and they put the name of the case and the party's name, and certiorari denied, automatic, no review. This is the Supreme Court of the United States. Folks, I didn't end there. I filed a motion before the 11th Circuit Court of Appeals seeking an en banc consideration. En banc means the entire court should review my petition. Folks, it's all scheme. Now, as soon as that 11th Circuit Court of Appeals get my papers, wherein I sought an en banc consideration, under another scheme, the routing clerk there assigned this case to this Judge Jael Edmondson only. So the other justices in that court, howsoever honorable they are, they don't know what's going on here. It's a scheme. You file the paper, it goes to a particular clerk, he assigns this to Judge Edmondson. And I am telling the court had no jurisdiction to consider the matter in the first place in 1986, and they accepted the case in error, and the judgment should be recalled. Mandate must be recalled. Judge Edmondson denies the motion. You will see his order. And he directs the clerk of the court not to accept any further papers from Mr. David, because he doesn't want to hear what I am going to say. And I already said, go to the Supreme Court again. Supreme Court, again in case number 15-9100. You see the docket of the Supreme Court. You Google it, you see the Supreme Court of the United States, and docket sheet, you see the decision. Petition denied. You understand? The justices, poor justices, who are as old as 86 and below, they don't understand the name of the game going on, because the law clerks assigned to them don't tell what has happened, what are the issues. You understand? This shakes the foundation of the US Supreme Court completely. They will resign en masse once the world understands the game is going on there. The poor justices, you have no way to contact them, because you can only write to the clerk of the court. The letters don't go to them. You understand? So the Supreme Court again denied my petition for writ of mandamus, writ of certiorari, in case number 15-91. I moved to the 11th Circuit again, seeking review of the facts here and to recall mandate. This time it went to same Judge Jael Edmondson and Judge Marcus. Marcus was in 1982 a district judge in Miami, and he ruled the same way in another case against the city of Miami. I'm sorry, he ruled in favor of me, against me in the city of Miami case, which was overthrown by the 11th Circuit then. So Judge Marcus is now brought here to the 11th Circuit Court of Appeals. He denies the same thing. Folks, what I have been telling the courts below, that is the 11th Circuit Court of Appeals and 2nd Circuit Court of Appeals and the US Supreme Court, is when a court has no jurisdiction to accept a case, but it renders a decision, notwithstanding the fact it has no jurisdiction, a judgment so rendered is void. I've cited so many cases here. This court had repeatedly, I'm reading from my brief, this court had repeatedly held in several other cases that when a court lacks jurisdiction, his judgment is void and a legal nullity, and it can be attacked at any time in any court, emphasis added, where its judgment comes into issue. Cases: Rose versus Hemley, 1808, 4 Crunch, 241, 2 LED, 608. Case number 2, Panover versus Neff, 1877, 95 US 74, 24 LED 565. Thompson versus Whitman, 1873, 18 Ward, 457, 21 1 ED for 897. Windsor versus McVeigh, 1876, 93 US 274, 23 LED. McDonald versus McBee, 1970, 243 US 90, 37 Supreme Court 342, 61 LED 608. These cases clearly say these are cases decided by the US Supreme Court in the past. When the US Supreme Court says in these cases, when a court has no jurisdiction, its judgment is a nullity. So what I'm telling the Supreme Court of the United States in my case is the same thing. The Tampa court had no jurisdiction to accept the case, and they rendered a decision, and that is a mistake, a terrible mistake. But under the scheme, the so-called law clerks assigned to these cases, namely a woman by the name Melissa Blarlock and Jeffrey Atkins, they say, no, the case has no jurisdiction, we dismiss your case. Folks, 2016, I filed case number 16-9624 before the Supreme Court. About the 11th Circuit's denial of my motion to recall mandate. Apparently, some blind men or ladies in the Supreme Court must have read what I am saying. So they read the court's order, which says, I'm going to show it to you. The original docket, the site, which says, Mr. David filed a frivolous and malicious action, and we are dismissing his petition to proceed in forma pauperis, but nevertheless we allow him to pay the docketing fee, and he can file 40 sets of brief. That's the order of the Supreme Court says. So I went to my bank, obtained a 20,000 rupee or a $300 bank draft, which you will see. I sent it to the clerk of the Supreme Court with 40 sets of my brief. This is one of my brief, one set. This was received on January 17, you will see here. January 17, okay? Can you see that? January 27, January 17, 2008. So they got 40 sets of the brief. Cost me more than 1 lakh rupees to prepare, get the exhibit tabs and get it bound and everything, and then postage. So as soon as the Supreme Court got this crazy woman, so-called legal analyst, I don't see her name on the list of the law clerks to the Supreme Court. Here is a list of all the Supreme Courts right from the beginning. I have a list I don't see this woman's name. Melissa Blalock. She may not be assigned to one of the justices. She is a clerk in the clerk's office. She sent them all back to me, including my bank draft and the 40 sets of brief in 4 boxes. You understand? Telling me to do what is in the order, which is what I did. The October 2nd, 2017 order says I can file the paper with the money. Which is what I did. This woman seems to have confused with the case number 15-9100, because that is what she shows in the body of her letter dated January 17, 2018. She seems to be confused because she is doing the same hanky-panky the other players were doing. I sent a letter to Justice John G. Roberts, the Chief Justice of the Supreme Court of the United States, with the check. So Judge John Roberts sent it back to the clerk's office, and now another guy by the name Jeffrey Atkins sent me a letter saying that the case is dismissed. On the one place, the Supreme Court says file the petition pursuant to the rules, which I did along with the fee, which they rejected and sent it. They sent to the Chief Justice, who directed the clerk's office to do the needful. Now this clerk, Jeffrey Atkinson, telling me the case is dismissed. Folks, under the rules of the Supreme Court, Rule 22 says a person can file a motion addressed to the justice assigned to the 11th Circuit Court of Appeal to reconsider the damn thing. What I did was comply with the court's order. Now, the clerk's office will not give my motion to Justice Neil Gorsuch, who testified before the Senate Judiciary Committee. He was asked, how will you rule on a case? He says, I will go first the facts of the case, then decide the questions of law. Now, these two clerks, Melissa Blalock, about whom I tried to research, there are so many Melissa Blalock, so I didn't know which law school she went to study law. The Supreme Court's rules say at the beginning of each term, the Supreme Court hires brilliant, bright students from well-known universities to assist the court. Is Melissa Blalock, is she from any well-known university? Does she know what she's doing? Or Jeff Atkinson? I found one Jeff Atkinson who used to work in the prison. I don't know whether it's the same guy. I tried to call them, they won't answer the phone. You understand? Another gimmick. We have a record of the number of times I called them from my Vonage telephone, which is toll-free from USA, and the number is 631-841-6222. But they won't answer the phone. They directed me to leave a message. They never ever bothered to return my call. My motion sent to Justice Neil Gorsuch, pursuant to Rule 22 of the US Supreme Court rules, was never given to him, although I sent it by registered mail with the tracking, and which the post office confirms was received by them within 3 weeks. I have the exact date, but we have the tracking number. Now, in response to my motion, I am getting another letter from Mr. Atkins, which reads, which I am going to show you. Under Article 3 of the Constitution, the jurisdiction of this court extends only to the consideration of cases or controversies properly brought before it from lower courts in accordance with the federal law and filed pursuant to the rules of this court. That's the last letter I am getting, without submitting my papers to Justice Neil Gorsuch. Now, the legal question I am raising, and I am going to refer this matter to the FBI and US Department of Justice and the US Congress, is, does the clerk of the court or his deputies have the right to decide on their own legal issues? The defendant's counsel, one Leon H. Lee, who is their current in-house counsel handling the case, has never filed any objection with regard to the jurisdiction of the court, because the one who committed the crime is the defendant's former counsel. You understand? The court had no jurisdiction. His counsel, the At&T's previous counsel, Peter Sinaba, along with the Kathleen Walbott and other lawyers, lied to the Supreme Court and the Court of Appeals. So, and the clerk of the court altered the judge's order. Now these two crazy people, Mr. Melissa Blarlock and Jeff Atkinson, is telling me under Article 3 of the Constitution or the Bull. Who is he to tell me? Do the clerk of the court have the authority to rule on a motion addressed to one of the justices and raise an issue which was never raised during the last 36 years? What were they doing? What is the problem in these two people submitting my motion to Justice Neil Gorsuch, who promised before the Senate Judiciary Committee how he will rule on questions of law based on factual issues here? Folks, there is going to be a tug of war. I'm not going to let them go scot-free. Howsoever powerful they are, politically, economically, they can bribe anybody in this country, in America. I'm not going to be cowed down by their threats and the cheap gimmicks they deploy. The world community must watch this documentary and the movie soon to be present to the world. Thank you, ladies and gentlemen, for taking the time to read. I have sent the chief clerk, Honorable Scott Harris, clerk of the US Supreme Court, a letter dated July 12, which is also published in Facebook, okay, telling him the same thing. The clerk of the court is responsible for the acts, omissions and commissions of his deputies. It is his job to ensure I get justice. I'm not a madman. I have not filed a frivolous petition as alleged by these two puppets and told the justices. When the fraud is committed by the players passing the ball among themselves, this is not a football game. This is a political football. Okay? Judge Reed colluding with the counsel for the defendant, going to her home and vice versa. When he resigns from the bench in disgrace, he passed the ball on to the next player, Terrell William Hodges, who refused to conduct a hearing and issues a judgment which was altered by the clerk of the court. So folks, I want you civilized people around the globe to know what's going on here in American courts. In Indian courts, of course, if you have the money and if you have a legal issue, you can go to the Supreme Court of India and have the case heard before experts. But in American courts, these judges who are in their late 90s, they don't know what the heck going on there. The clerks, the tail wagging the dog here. The clerks control the Supreme Court. The clerk of the court below, the clerk of the district judge, district court, they play the games. This is where the corporations pump money. To case one, why Clarence Allgood committed suicide? These are questions people with the brain should ask themselves. Am I lying to you? Folks, I'm so mad. The American fucking system has screwed up the whole version. They say they only hear 80 cases out of the 10,000. What about 9,000 plus cases, howsoever meritorious? How they go without any justice? You can't have a fixed system. It's not a lottery. We only give prizes to 80 people, the others go scot-free. That's a screwed up system. American Supreme Court must raise the number of judges, active judges, who have the brain. I'm not saying the others don't have. But when you reach the 85 and 86, your faculties of thinking goes down. And those who fear the justices, they are corrupt. Thank you for listening to me, gentlemen and ladies. Think it over. Think it over. Contact me if you want to. Send me an email. My mail is being bugged. My phone line's bugged because the At&T is restless. They don't know what to do. You understand? It's a major corporation doing all the hanky-panky. The world should realize what's going on here. Thank you.